I don't like that person actually. All the government parents are like that. If this person, really I don't want to do anything because of more. I just want to but he's saying this also. Next day he'll come back and ask us for it. After we joined the आसपास में भी भटकने करते हैं very unpredictable. They understand. तो अपना मूड भी चलता है. That stage is gone. Now we are ready for the hearing. I'm not opposing that. I said let's go now. We will not allow you to prepare the paper since we are not going to hear that.
Your Lordship.
Tell me.
Your Lordship, I want to mention item number 8. May this matter come to the next week.
You are for?
The respondent side.
I'm for the petitioner.
Any objection?
No objection.
Respondent what?
4.
4.
Yes, Your Honor.
What is your ground?
So,
What is your ground? You've asked for time.
yes,
On what ground?
sir, because my senior counsel is indisposed for today.
Who's your senior counsel?
Advocate Rakhal Devnath.
On made by the respondent 4. Not objected to by petitioner. List this matter up to 2 weeks.
Much obliged.
Your Lordship, I beg to item number 12 of the hearing is. And for the respondent, Contempt counsel is on leave. Mr. Sen.
You are for?
For the respondent.
Respondent.
Petitioner, no objection, Your Honor.
No objection.
No, Your Lordship.
On made by the respondent. Not objected to by petitioner. List this matter up to 3 weeks.
I'd like to mention item number 14, Your Lordship.
You are for?
For the petitioner, Your Lordship.
I'm for the respondent, Your Lordship.
Respondent. Any objection?
It's all right. This is against this clubbing of matters, my lords.
Oh, that.
Ma'am.
Okay.
It's question of law only.
On made by the petitioner.
Your Lordship, 3 weeks. May kindly be
3 weeks. On made by the petitioner, not objected to by respondent. List this matter up to 3 weeks.
Yeah, Your Lordship. For item number 15 here. I was informed by the counsel for the respondent number 5 that she's ill, so she's not unable to be there for hearing, Your Lordship. So she's praying for 1 week's time, Your Lordship.
Who's for the petitioner?
I am for the petitioner, Your Lordship, but
You are for the
I was
petitioner.
informed by the counsel for the respondent number 5.
Or made by the Respondent number 5, not objected to by petitioner. List this matter after 3 weeks.
Lordship, I beg to mention item number 9. Hearing list.
You're for?
I'm for the petitioner, Lordship. Lordship, Mr. Paul is appearing in this matter. Today he is not here, my lord. So therefore,
On prayer made by the petitioner, not objected to by respondent. List this matter after 3 weeks.
Lordship, similar prayer for item number 10 as well.
Same.
Highly obliged.
Lordship, I beg to mention item 4 of the hearing list. Lordship, if
I think this court has made it clear, no more adjournment. As far as this matter concerns, 2014 matter.
Lordship
If
will
we
take
keep
it
on
up
going
next.
like this, I don't know when we'll end.
Lordship will take it up next week. Lordship.
That's always the, the prayer. Next week comes, something happened. This matter has been heard.
Yes, my lord, to certain extent, because with one name, 2 schools are being run,
So this is the-
and the inquiry report was submitted, and thereafter the case has been pending for further hearing.
This is the problem. You see, if it has been heard, then it get adjourned to 2-3 weeks or 1 month or so. Then it's very difficult for the court to recollect.
Your Lordship, last time it was heard that the respondents were directed to file an affidavit with regard
That
to
has been done.
That has been
that
done.
has been done. So after that, there were exchanges of affidavits.
What you can do, miss, you can start. You start with whatever, to whatever extent you can complete, and we'll see. Otherwise,
Today I'm not. Lordship, I'll take it up next week, Your Lordship. Even if Mr. Paul is not here, I'll take up the matter.
on pre-made by the petitioner, list this matter on.
Today is 4th, Your Lordship.
12th will not be here. List this matter on 11th.
Your Lordship. Highly obliged.
My lord, I beg to mention item number 5, my lord. I'm praying for 2 days' time, my lord. Let it come up on Monday, my lord. Need some time to prepare the matter, my lord.
Then a counsel for the petitioner has submitted that she is not prepared with him hearing of the matter today and has prayed for 2 days' time to be accommodated. On pre-made, list this matter on 8th.
May it please your Lordship. Lordship, I beg to mention item number 6 on behalf of Mr. Hazarika, Lordship.
It's also 2016.
Yes, Lordship. Lordship is our station, and I was just informed about.
Mr. Hazarika,
Yes, Lordship.
he is appearing for the state.
Yes, Lordship.
Who is for the petitioner?
Petitioner 6. Yes, Lord. 6. Yes.
I am appearing the petitioner.
Yes. Any objection?
Since he's not there.
On pre-made by the respondent, state respondent, on pre-made on behalf of the Leonard GA, appearing for the state respondent, who is said to be indisposed for the day, and on no objection by the petitioner, matter is adjourned. List this thing after 1 week.
Obliged.
Really causeless item number 1.
May I please,
Yes.
to appear in item 1 and 2, my lord, for the petitioners through VC, my lord. Lordship, these are anticipatory bail matters, wherein on the last occasion, my lord, Lordship had been pleased to grant us interim protection, as well as direct for production of the CD, my lord. The case was that there was a tussle, my lord, near the liquor store in a village in West Jaitya Hills, if your Lordship recollects. An FIR was filed, my lord, by the brother of the complainant, all members of the, my lord, NGOs, alleging that there was an intentional stabbing. It was our case, my lord, that there was a hustle and tussle because of, my lord, demands made by the alleged victim. And
By the way, Mr.
So, my lord,
by the way, Mr. Dev,
Lordship.
have you, since you said that there was a demand, have you filed any FIR in that regard?
No, why, my lord? It was all in the same day. It was a series of events in the same day, my lord.
It doesn't matter. It may be on the same day, but it's incumbent upon you. If you have, made any specific allegation, you should have filed an FIR.
No, that instruction I don't have, my lord, because at that point there was no incident per se. So perhaps, but I don't know, my lord. But in any way, my lord, the CD has been, I believe, my lord, the CD has been directed for. So Lordship may peruse the CD, and it would be my humble submission, my lord, that on Lordship's satisfaction, the interim protection may be made absolute, my lord.
We have received the CD, Your Lordship.
Yes, tell me, what is your submission?
May it please Your Lordship. On the last date, when they moved the pre-arrest bail application by both the petitioners, Your Lordship, they had contended that it was an act of self-defense, where the victim person who was stabbed, had drawn out a pistol and attacked these two people. But Your Lordship, on perusal of the CD and on the statement made by the eyewitness, Your Lordship, both under 161 and 164, Your Lordship, it appears that this is not the case. The statements made by the petitioners in their application and at the time of submission before Your Lordship is purely misleading, Your Lordship. The fact remains, Your Lordship, that these two people, the petitioners, were in the liquor shop. It was not the case that they had gone to the liquor shop and met Solomon Rambai, the victim, who was already there, but it was these petitioners who were already there in the liquor shop, and they called the victim over their phone, and the victim arrived. They sat down together, had their things, and then there was an altercation. That is the statement made by the owner of the liquor shop. There was an altercation, and then when the owner, this gentleman, Your Lordship, Shanki Rani, when he saw that this was going little out of hand, he requested Solomon Rambai to go out, and he took him out. The victim, that is, when he was being taken out, these two petitioners, Your Lordship, they followed and stabbed him. And it was not one stab wound he has sustained, Your Lordship. Several stab wounds are there in his body. And after he fell down also, Your Lordship, they tried to ram him over with the car, Your Lordship. And according to the IO, Your Lordship, there is no pistol, no mention of the pistol anywhere, neither by the eyewitness. And IO has also stated that he searched for everywhere and he found nothing there, Your Lordship. That incriminates the victim, that it was he who had started the assault and not the petitioners, Your Lordship. It was actually the petitioners, Your Lordship, who have provoked, who had started the altercation and attacked the victim, Solomon Rambai, Your Lordship. So my humble submission is that Your Lordship may peruse the CD, and even the medical report, Your Lordship, says that he has sustained several injuries on his body, stab wounds, and his intestine had also, his intestine had also come out, and he had sustained grievous injury. It is not at all a case of self-defense. And at no point of time has any other witnesses mentioned that these people have got any link with the NGO HNLC. But of course, the victim, he is an active member of HITO, but there was no demand made by him, Your Lordship, as per the IO. The FIR also gives the name of both these petitioners, Your Lordship, who are the actual perpetrators of the crime and not. Then the statement under 161, Your Lordship, the victim has also stated what happened, after he recovered. He was in the hospital in the ICU for a month. After he became a little better, he has given a statement.
So there was no history of conflict between the...
No, Your Lordship. At no point of time there was any conflict. It was these two petitioners who had called the victim to the liquor shop. And not the other way around, because when they were making the submission before this honorable court, they said that Mr. Solomon Rumbai was already in the liquor shop when these two people arrived there, and it was Solomon Rumbai who took out a pistol and tried to attack them, and that they had acted in self-defense. Your Lordship, I would like to take Your Lordship this flag marked as CD 17 dated 20th April 23.
Just a moment. Have you got a copy of the CD with you?
Yes, Your Lordship. I've got a photocopy. The original is with Your Lordship.
Can you just... There are so many tales here, I don't know what is what.
This is CD 817, Your Lordship. It's flag marked as CD 17, dated 20th April 23.
Just a moment.
After the interim bail granted by Your Lordship.
Okay, 20th?
April 2023.
Yes, so...
So here, Lordship, the IO has reproduced the statements made by both the petitioners, and then at 1 and 2, and then he goes on to say that, but it is also worth mentioning that as per the statement of the eyewitness, who is also the owner of the shop, Shri Shanki Sari, stated that it was Damut Bang and Palman Sari who first came at his shop. He even heard that Damut Bang and Palman Sari normally spoke to Solomon Rumbai over his mobile phone through loudspeaker. And after a few minutes, Solomon Rumbai arrived at the shop. Solomon Rumbai is the victim, Your Lordship. The eyewitness also stated that an altercation started inside his shop. Despite his best effort to intervene the matter, he was not able to stop them as he was alone. After they went out of the shop, arguments was getting worse, and at that moment, Damut Bang took out a dagger and stabbed Solomon Rumbai several times on his belly, to which as a result, parts of his intestine came out of his stomach. It was an attempt to murder. It is also to be noted that the eyewitness has never mentioned about the pistol possessed by the victim Solomon Rumbai, and I also have thoroughly searched the PO but could not find any pistol or knife in the PO. A medical report of the victim has also received, and the MO opined that the victim sustained several stab wounds. Intestines came outside with the bleeding from multiple sites at the time when he was brought to Dr. Norman Tunnel Hospital at Juai. Further, in the process of my investigation, I found that the victim has no link with the banned outfit, HNLC, as alleged by the accused person, Damut Bang, but he is an active member of HITO. Furthermore, if the allegation of the accused person is genuine, they could have lodged an FIR because they had said that the victim had demanded money from them. In that case, they should have lodged an FIR to the concerned police station or any other police station or outpost. But rather, they have evaded the police arrest and disappeared soon after the commission of the crime. Lookout notice has been issued, Your Lordship. Then I would like to take Your Lordship to the statement of the eyewitness. Under section 164, Your Lordship.
The owner of the liquor shop?
Yes, Your Lordship. My name is Shanki Shilla. My father's name is... It was on the 9th of March 2023 at around 7 p.m. in the evening when I reached the tea stall. I saw Shri Damut Bang and Palman Sari in the stall, and they were talking over the phone to Solomon Rumbai, and they kept the phone on loudspeaker, and after about 2 minutes, Solomon Rumbai came to the tea stall. At that time, I went outside the shop to wash my hands and feet. It was at that time I heard them quarreling. Then I went inside the tea stall and tried to pacify the situation. I advised Solomon to go away from there while I was holding Damut back, but he could not as he was intoxicated. I could see that the intention of Damut was not good towards Solomon. So I asked Palman, this is the other petitioner, Your Lordship, to hold on to Damut while I tried to help Solomon to get him to his car. But at that time, as Damut was free, he grabbed a knife. I could not help Solomon as Damut held a knife and he stabbed Solomon. Thereafter, people started to gather and Damut and Palman ran away from the place of occurrence and Solomon was lying on the drain. Then people informed the Waheshnong, the police and the family members of Solomon who took him to the hospital. So, Your Lordship, my humble submission is that the evidence is very clear that there was a deliberate attempt to kill the victim by the two petitioners, Your Lordship. And the petitioners are still at large. Lookout notice has also been issued, and the medical report is also there.
After the interim bail was granted to them, they had appeared before the IO.
They have not appeared, Your Lordship.
Oh, they have not appeared.
That is my instruction, Your Lordship, that they are still at large. Even there, Your Lordship, in that CD of 20 April, they are saying that the accused person is nowhere to be found. They are evading arrest, Your Lordship. Self along with staffs have made several attempts to look for the accused persons in the residence and suspected.
You're reading?
The same CD dated 20 April, stating that they are residents and suspected places, but they were nowhere to be found. Hence, it is strongly believed that the accused persons were involved in the instant case. Nowhere has he mentioned that they have appeared before him even after the interim bail was granted to them.
But if you read that CD, noting of the CD on 20th April, it says that it is to be noted, it is to be noted that after perusal the bail petition of the accused person, so and so, to the Honorable High Court, both the statements stated as follows. So that means soon after they have come, appeared before the IO.
Yes, sir.
Just to note that after perusal the bail petition of the accused person, Shri Damut Bang and Paul to the Honorable High Court, both their statements stated as follows. This is the statement, but again here at the end, that is according to the bail petition, Your Lordship.
No, whatever the case may be.
Your Lordship, it is not the statement. He says that after perusal of the bail petition of the accused.
Yes.
Damut Bang, sorry, to the Honorable, that both their statements, that their statement in the bail petition, the statement in the bail petition before the Honorable High Court. That is what I understand, Your Lordship, by this note given by the IO. Because at the end he still says that the accused persons are at large and they are not to be found anywhere. Because here he says, it is to be noted that after perusal the bail petition of the accused persons, Damut Bang and Palman Sari, to the Honorable High Court, both their statements stated as follows. That means the statements made in the bail petition.
What is the minimum qualification for service in the police department?
Because this is what he has reproduced. He has perhaps reproduced the bail petition.
They might as well record the whole thing in the vernacular language.
Because if you read this, Your Lordship, it is obvious that he has perused the bail petition and has reproduced that as their statements. Because there's no statement under 161 also. Of both
that should have been there.
And there's no statement under 161 of the... We have the statement of the Rongbashnong, who doesn't know anything, but that he was only informed. The wife of the liquor shop is there, I mean the owner of the liquor shop. Then the complainant, the brother of Solomon Rumbai is there, but not of the two accused persons, and the eyewitness is there under 161 as well as 164.
Yes, Mr. Deb, you have anything to say?
Lordship, I don't know what is there in the CD. Whatever I have submitted, my lord, is the narration of the petitioners themselves. And since their statements are not there, my lord, the picture still remains slightly unclear in my humble submission. And my lord, if it was the case that he was stabbed multiple times and his organs, my lord, were, my lord, in a bad shape, there's no mention of those things in the FIR. That is, my lord, another thing. And my lord, whatever may be there in the CD, the interim protection has been granted, my lord, and there's no question of evading arrest once the protection is granted. It is my instruction, my lord, that they were never called. Perhaps they were of the impression that they would be called by the IO.
The
But
IO
whatever
has
that may
searched
be,
for him, for both the
they
petitioners,
are very much
everywhere.
available. It is my instruction that they were very much available, my lord, and there's no question of evading arrest because the protection is already there. So Lordship may see that, my lord, that there's only one witness who says to be the owner of the shop. He doesn't really talk who has started the altercation and how it came to be, and he doesn't know about the history. It's only because I have not lodged an FIR, my lord, of what happened on earlier of the same day. That may not be a ground to, my lord, assume that there was no history. And had the statements been there, my lord, that would have given us a better picture. So I would pray, my lord, that again with the undertaking that the petitioners, my lord, are not evading arrest, and they are, my lord, they will undertake to cooperate with the investigation. I would pray, my lord, that the anticipatory bail may be granted with the stringent of conditions, my lord, and they shall be ready to cooperate, my lord.
Lordship, I would also like to take you to the medical report given by the doctor, Lordship, who clearly says that he was stabbed several times, so many injuries are there, and that his intestine was out.
That may be, my lord.
No, because you had just said, he had just mentioned that there is nothing to show.
Prima facie, it is established.
Yes.
That there has been,
there has been attack on the, and it was not a case of self-defense.
There was an altercation.
Because your Lordship was pleased to grant the bail to these petitioners. They had contended at that point of time, when we did not have the CD before us, that it was the victim who took out a pistol and tried to attack them, and these two petitioners, in self-defense, they had stabbed this thing. But in this case, your Lordship, it is very clear. The eyewitness says that it was Damot Bang who started the altercation. And even when the eyewitness was trying to take out the victim out of the shop, Damot Bang followed and stabbed him before he could stop the conflict between them, your Lordship.
See, madam, after the court has passed the order,
yes, your Lordship,
interim bail was granted to them. Now the IO has continued with his recording of the CD. Is there any remark in the CD that the two accused are required for custodial questioning or interrogation?
That has not been given, your Lordship. But then the IO has stated in the same CD, your Lordship, of 20th April, that they have tried their best to look for them. Their mobile is switched off. They went to the residence, to their place of work, and they have not found him, and that they are evading arrest. At the last part of the statement, your Lordship. Even the vehicle car is missing, your Lordship. I mean, the car is found, but the key was missing. Of 20th April 2023, at the last portion, your Lordship. The last part of the thing. Self, along with staffs, have made several attempts to look for the accused persons in the residence.
Just move. Please lead this court to that portion.
This one, your Lordship, in the second page of that CD, your Lordship, 517. Furthermore, if the allegation of the accused person is genuine, they could have lodged an FIR to the concerned police station or any other police station or outpost. But rather, they have evaded the police arrest and disappeared soon after the commission of the crime. Self, along with staffs, have made several attempts to look for the accused persons in their residences and suspected places, but they were nowhere to be found. Hence, it is strongly believed that the accused persons were involved in the instant case.
Heard, Mr.
That is, before the before the bail was granted, I believe, my lord, because they say.
See, Mr.
Wait, wait,
Dev,
wait.
see, Mr. Dev, this is a noting of 20th April.
After your
That was
lordship granted,
after the bill order was passed. So they must have been.
There is no reason to, my lord, to not appear
it's a clear
Exactly.
before the
case.
IO had to be called, my lord. It means my submission, my lord, that they may be directed to appear tomorrow itself, my lord. If they don't go, then lordship may consider otherwise, lordship.
Unless the. My humble submission is that the anticipated bail
Because
will
unless
kindly be
their statements
rejected,
are
your lordship.
recorded, the picture still remains unclear in my submission, my lord. Because I understand, my lord, that a very
They
contrary
have
picture has
misled
been
the court on the first day
by the
also, and
CD.
now also they misled.
I've heard Mr. S. Dev, learned counsel for the. I think I'll pass a common order.
Yes, your lordship.
Lordship may. Yes.
Learned counsel to the petitioners who were both implicated in the same case. That is.
Joy PS case number 31 bracket 3, my lord.
This court, by order dated 19/4/2023, on the prayer of the petitioners for grant of pre-arrest bail, had enlarged them on interim bail pending perusal of the case diary to ascertain the stage of investigation carried out by the IO. Today, when the matter was called up, the learned AAG has produced the case diary and has also led this court to the contents thereof, particularly to a noting by the IO on 24/2023, indicating to the extent that after the order of this court, the IO had examined, the IO had made an attempt to look for the said accused person, perhaps to record their statement or otherwise, but even after several attempts were made, the said accused person, petitioners, were not to be found in their residence. Which has given an impression to the IO that they are evading or rather not cooperating with the investigation. It also transpired from the contents of the case diary that the facts of the case was not as projected by the petitioner in their earlier submission before this court, but in fact from the account of the eyewitness, particularly the owner of the said liquor shop, what could be understood is that the petitioners were already in the liquor shop when they called the victim over mobile from the mobile phone, and when he came to meet them, in the process there was an altercation and an apparent altercation, after which the victim was ushered outside by the owner of the said liquor shop, but soon after he was followed by one of the petitioner who stabbed him several times in the stomach, to the extent that the victim has to be hospitalized and was in the ICU ward for about a month or so. Prima facie, it appears that the case involved a very serious offence and subject to further evidence, perhaps a case under 307 IPC may be made out. However, from the conduct of the petitioner, it appears that they have failed to cooperate with the investigation, and as such, the liberty given by this court was flaunted. Accordingly, this court finds no reason to continue with the interim protection given to the petitioners. The petition is hereby dismissed as devoid of merit. The interim bail granted is hereby discharged. The IO is directed to take necessary steps in this regard. Petition disposed of.
With the petition.
CD, I'll not record that the CD is given to you. You can just take it.
Obliged.
Thank you.
Item number 3.
Please, Your Lordship. Lordship, in this matter, we have taken steps on respondent number 5, that is the private respondent. Service is complete, my Lord. We filed an affidavit of service.
Who is the respondent 5?
Respondent 5, my Lord, is my neighbor in Nongpo. It is based on his complaint. We have a private dispute, my Lord. His allegation is that my drain adjacent to his boundary wall, water seeps into his compound. May or may not be true, but based on on account of a private dispute, magistrate has drawn up 133 proceedings.
No, but if there are those kind of complaints,
yes, ma'am,
it would be better to to sort it out among yourself.
Absolutely.
What is there?
Lordship is very correct. And more importantly, my lord, private disputes through private disputes, on account of private disputes, 133 proceedings cannot be drawn up. That is the only contention.
There's no question of breach of peace or otherwise.
Nothing of that sort, my
lord. They will get involved in fisticuffs.
Nothing of that sort. Nothing of that sort.
What is your report?
There's certain compliance. They were required to comply. That has not been completed yet. So as it's rightly foreign from your lordship, if they can settle among each other, nothing remains.
Those are small matters. Need not come to court.
Lordship, the last part is very relevant.
The only reason, my lord, we had to come before this honorable court to take up honorable court's time is because magistrate passed a verbal order instructing the police to shut down all businesses which are operating on my.
That is also not.
That is
that protection they got in the interim. Lordship, we admit that is. I don't think so. Magistrate should have done that.
Over a drain, you have to shut the shop.
And not just my shop. 42 of my tenants, for no reason, he shut their shops.
Okay, we'll do one thing. You try to.
Lordship will kindly see that clause 9 only. The last part. Only the last part.
Copy.
Who is the respondent? Respondent is the
private respondent.
Private respondent.
So if
He's
both,
also at fault.
absolutely. So if both, that is the reason we are state, we are neutral players. So if they can sit and complete that part, matter ends.
We'll do one thing, Mr. Jindal.
I wish the respondent was before the court.
The interim protection will still be sustained.
It is continued.
What you can do is you reach out to the
5.
Respondent 5.
Number 5.
Try to sort it out.
Very well.
Say that it is, since he is not here.
Had it been here, we
you
would
tell him
would
that
have.
it has fallen from the court.
Very well.
That they try to solve this matter.
Very well, my lord. A small request, my lord. What has happened till date is that whatever complaint he has filed with the DC office in Nongpo, till today, my lord, we don't have a copy of that, number one. And what my senior has submitted today, I believe it's some sort of status report from the magistrate. If a copy could be given, maybe that will help us in convincing number 5 that.
Give a copy of the complaint. You have a copy of the complaint with you? This is the complaint.
No, this is the
report. Is the status report. He wants a status report.
No, he wants a copy of the complaint.
Lordship, he can apply for a certified copy from DC office.
Could have done.
He could have done by now, certified copy.
No, my lord, the respondent in this report is me.
Okay.
The allegation is that apparently I have not done the work.
Then Lordship, all the more reason that if you can just comply with this clause 9 and submit a report.
There is no question of compliance because I am before this honorable court on a different footing, my lord. My case before this honorable court is not on facts whether I have complied or not complied. In fact, I have complied. Till today, magistrate has failed to point out how have I failed in compliance. When he passed that verbal order to shut down all businesses, next day also we gave him a written representation saying that, look, please inform us how have we fallen short. We'll make up for it. His response on our written representation was he wrote a one-word order on the face of the representation, rejected. Now that is a very dictatorial approach, but leaving all that aside also, we are here before this honorable court on a different footing, my lord. Our case before this honorable court is in a private dispute. 133 proceedings cannot be drawn up.
Oh, that is beside the point. So now we are not on that.
Yes, ma'am.
On the technicality,
yes, ma'am,
or the legality of it,
yes,
you know. First, let's assume that
yes,
it is a private dispute.
Yes, ma'am.
It's a question of dispute between neighbors.
Yes, ma'am.
So for all intent purposes or practical purposes for that matter, yes, it is it doesn't augurs well for neighbors to get into a dispute.
Yes, ma'am.
In the long run, you have to stay together.
Absolutely.
You can't shift land somewhere or the other.
No question.
So, given that situation,
yes, ma'am,
like I said, if there is really a case that could be a situation that could be rectified by either side,
yes, ma'am,
that should have been the first course of action, irrespective of what the magistrate has directed.
Yes.
So if that is solved,
yes, ma'am,
I think everything will fall into place.
Appreciate that, my lord. I am in complete agreement with what has fallen from lordship's mouth. In this case, what has happened, my lord, once the proceedings were drawn up, we complied with whatever we were directed to do. Magistrate told us, you cement the drain. You put up a lining, cement lining, we did that. Magistrate told us, you repair your neighbor's wall. There were holes in his wall. You repair his wall. We repaired his wall also. After that, on the date in question, 5th April, he comes for a spot inspection, a surprise inspection, along with police. He inspects the place. He said, work is not satisfactory. We asked him, how? Tell us, how is it not satisfactory? Work is not satisfactory. He told the police, shut down everything out here. So we have attempted, even without getting into the legalities, etc. We have attempted to comply with whatever.
What is the response of the neighbor or the private respondent?
Lordship, he has refused to. He has filed whatever complaint he had to file. After that, he has not participated at all in the proceedings.
No, but you see, after that, you said you have done the needful.
Yes, my lord.
You have repaired you have cemented the drain.
Yes, my lord.
Repaired his walls.
Yes, my lord.
And was he not satisfied with that?
Lordship, because he has refused. He has stayed in the background throughout. He filed the complaint. After that, he did not participate in the proceedings. Before this honourable court, also he has refused to enter appearance in spite of receiving notice. So I cannot speak for him. What is in his mind and what is the level of satisfaction or unsatisfaction that he may possess. My humble request to this honourable court is to kindly appreciate that we have done whatever we were required to do and whatever was possible to be done. If we have still fallen short, it is incumbent on the magistrate to tell us how we've fallen short. We have undertaken to him, after he passed that verbal order to shut down the business, next day we went to him with a written undertaking that we will comply with what you want us to do. Give us some time and point out how have we fallen short. His one-word response, rejected. So, my lord, we are at a loss. We are at a loss without, as I said, without getting into the technicalities of the proceedings, the legality of the proceedings. We have attempted to not really complicate matters and comply with whatever requirements are there. But in spite of that, we have apparently fallen short. How have we fallen short? We still do not know. So, point being, my lord, we have done what we could. Now we stand before this honorable court. Our prayer is that the proceedings have to be closed, my lord. They are illegal proceedings. We are, frankly, my lord, not to appear, not to sound rude, but we are tired of complying repeatedly, and at the end of it being told that we have fallen short. How? Even that is not explained to us, my lord. So the status report my senior has submitted, but point is that honorable court has not really asked for any status report to be submitted. So I reserve my rights to make submissions against the status report. But as on date, my lord, with respect, I'm afraid this honorable court may have to confine itself.
Prima facie, it appears that perhaps the London magistrate has overstepped his jurisdiction.
There's no denying. There's no denying. We have to admit, we have to assess the court. There's no denying. You can't write an order and reject it. That part, Your Lordship, as Lordship rightly said, there's a technicality. That part of it has to go. But the larger issue, as Lordship rightly said.
Yes, like I said again, if he at the bar has submitted that the drain was repaired and all those things, what remains?
Lordship, if I can suggest, since we have given the status report and he intends to at least rebut or reply or say he has been complied with, let him file a small report. We may get a chance for the other party to appear also, and in the meantime he can file a small report saying what he has complied with. Then court can pass an order.
It's on record.
Should the court direct the magistrate to conduct another inspection and file a detailed report?
Yes, to file a detailed report and focusing specifically on what measures are yet to be taken, if there are any measures, because till today we are not aware what else is required to be done by us. But if any such order is passed by this honorable court, it may not prejudice my right to agitate against the legality of the entire proceedings, if required at whatever point in time.
Perfectly correct. I think it's correct. On the specific query as to what has remained and what has not been complied, what has remained, let him submit it.
Because this is now again we are stuck in a situation where the respondent 5 is not before us.
He is not appearing.
You have arrayed him.
Had he been here, Lordship,
had he been here, we could have got his response, or otherwise.
My suspicion, my lord, and buttressed by the fact that till today in Nongpo, before this honorable court, he has not come in the picture. My suspicion is it was just done just to harass.
133 is public nuisance.
Public nuisance through water, etc. My lord.
But Lordship, in the meantime, if you can, as rightly said, if you can, a small inquiry can be conducted and what has not been complied. That can be done again, and the matter can be closed since the other party is not appearing.
Public nuisance, my lord.
So the PO is a private property.
It's a private property.
Lordship, if I may just satisfy. Lordship, can you allow me to read 133? The relevant part, Lordship, is whenever a district magistrate or subdivisional magistrate or any other executive magistrate specially empowered in this behalf by state government on receiving the report of police officer, Lordship.
Yes.
We are not concerned with police officer, Lordship, or other information. Other information, it's open.
But the purport of the of this section is only confined to public.
No, Lordship. Lordship, allow me to come to A. Lordship, allow me to come to A. So there are two situations. There should be a report by the police officer or other information. The other information would include anybody. My submission would be first, Lordship. And A, Lordship, that any lawful obstruction or nuisance should be removed from any public place.
Yes.
Lordship, we are not concerned with public place or from any way. So, Lordship, the first importation is information from any source. Second is from any way.
Yes.
So we require interpretation if at all. Or what is the meaning of other information? My submission would be anybody.
Used by the public.
Exactly. My senior has to read the full
No,
sentence.
Lordship, yes, absolutely correct.
Any
Lordship.
way, river or channel which is or may be lawfully used
Lordship,
by the public.
allow me to- not that I am correct, Lordship. I'm not for a moment I am saying I am correct, but I am saying that if it requires interpretation, will require any public place or any way. Lordship will see there is a comma. So there are two conditions, either or, public place or any other way, comma. Then river. So your Lordship, this word from any way, comma, river is independent. Then again we come, your Lordship, or. First is public place, we have or, and we have got a isolated situation which could be from any way or river, a comma river. There is no comma here. Then after that or channel which is or may be lawfully used by the public. Lordship, I want to go back to my school days. And would be both the situation. Jack and Jill went up the hill. Both went together.
Lordship, can I intervene?
Jack or Jill can go up the hill. If both are independent, Your Lordship, both cannot go together. The legal interpretation of and or is very, very serious in law. And we have to interpret, if we require then Lordship, we will have to interpret what is the meaning of way, and after that way there is a comma in river. There is no or in the river, but after or.
Yes.
So if you take
this or is only with regard to river and channel.
Absolutely.
So now we are not on that.
Lordship, we are not in that. Now from before public place or from any way. And
See,
comma.
Way, river and or channel has to be read together.
Lordship. Lordship, I slightly disagree. Before river there is no or, but after river there is or.
Lordship,
my submission would be.
Supreme Court has interpreted 133. I have many judgments. I'll place one judgment, my lord, just to cut the matter short.
Let him finish.
No, Lordship, I agree. We've gone through the judgment. Lordship, can you appreciate one part?
He wants to show his English skills. So
I can see that, my lord.
There are some occasion that comes. I'm sure he's going to interpret public nuisance. But Lordship, kindly appreciate one thing.
Please go ahead.
Lordship, kindly appreciate. Let him produce one judgment of Supreme Court which has interpreted other information from any way. Let him produce one judgment on that. On public nuisance between two disputes, we agree with it. Now, it is not the case, Lordship, that not the case that the law on public nuisance is not clear. It has to be a case of public nuisance. Here, Lordship, in the first part, other information. Kindly, if I'm not saying I'm correct on that. If there is a Supreme Court, I recall back my argument and I would succumb to it. But there is no judgment on the word other information from any way. Now we will have to interpret, Lordship. This is a serious question of interpretation. We are told we want to venture out. Because after way there is a comma and then river. Very interesting is this, after river there is a or. Now when I said, Lordship, let me go back to my school days, we have to go back to the basics. And means both. Like Jack and Jill went up the hill. It can be both. Jack or Jill can go up the hill. Both can't go together, Lordship. So public nuisance is an independent category where police officer comes in. I'll just try to persuade the court on that. Maybe I'm wrong, but allow me to just persuade the court. Public officer and public nuisance go hand to hand together. If there is any other information, and if there is any other way, the word used is, Lordship, from any way. Now, how do we interpret the word anyway? There's a comma and river, and after that there is or.
So you mean to say that the word way has to be taken in isolation?
And the Lordship, anyway.
Anyway.
Lordship can take any, not for a moment, in Lordship, I'm persuading the court, the Lordship will kindly agree with me. I'm aware of the fact that there could be an interpretation. I am just forwarding a plausible interpretation that the word any is used, it will be inclusive. It will be inclusive, and any information would be independent of police officer and public nuisance. And if maybe an opportunity is presented itself before this court where we can venture into it. In either way it happens, it is not the case of state, Your Lordship, that it should be interpreted the way I am submitting it. But my respectful submission is this, Lordship, the dispute that has arisen here will will be fortified with other information and anyway, comma. Except if there is a better interpretation, Your Lordship. Lordship is aware of the fact also, like if there are two possible interpretation. Any interpretation that favors the legislature or would get the meaning correct. We cannot foul play in interpretation. It has to be the meaning of that.
Anyway, Mr. Khan, we'll not go.
Thank you for indulging.
We will not go into that because that is just.
Can I respond, my lord?
What we can 2 minutes. See, Mr. Tindal, once again.
I agree with the suggestion. Let him file.
Like what I said. See, the respondent 5 is not here.
Yes, ma'am.
Absolutely.
So, now, if he is not here, we cannot pass any order which may be determined.
Absolutely correct.
Notice has been served.
Notice has been served. You have filed your.
Yes.
But we should allow him at least to appear.
Very well. We can give him one more chance.
We'll give him one more chance.
Very well. Very well.
You can also, anybody can inform him for that matter.
True.
Lordship is very correct. If once he can satisfy, that issue is factually, I consider, Lordship, that the order is, on the face of it, something is wrong. And I also said that he can't just reject it by saying, not hurt. But the larger issue is this, how do we resolve the issue of that dispute? Whether if it's completed...
But if it is what has been submitted by the petitioner, if it's a question of a private dispute, there's nothing to it. Since the parties will have decided among themselves...
He can persuade the respondent of 5, cajole him to come back and say, let's solve the matter. It's a matter of dispute.
I wish Lordship would have given me the chance to respond to the nursery rhyme. I had my own nursery rhyme in response also.
No, Lordship, his nursery rhyme is public. I am with him.
Mine was Humpty Dumpty sat on the wall. Humpty Dumpty had a great fall. That was the fate of the interpretation, as per the Supreme Court's judgment.
So you're referring to this?
No, Lordship, basically
referring to the judge sitting here.
He's referring to the court.
No, my lord. The interpretation that has been advanced, it would have fallen in view of the judgments of the Supreme
Court. I don't understand, Lordship. Why is my friend trying to mislead the court? We are not into public policy and police officer. That judgment is all about public policy, Lordship. Let him produce one judgment on the meaning of the word.
Since the court has ample time, so this banter is allowed. Otherwise, it's a waste of court's time.
It is
Lordship, if I may submit it, sometimes it's not only about relief. Sometimes it's also enhancing, fine-tuning the jurisprudence of criminal law. Lordship, why should the Delhi High Court always take privilege on that? We have a very able High Court in Meghalaya too. Maybe this could be one of the precedent in case we decide he wants to decide.
If it comes to that, once we get into the meat of the matter, then that's
it. This particular clause should be interpreted, and why not Meghalaya High Court should be in the anvil of India?
Supreme Court has done it, my lord. It will be reinventing the wheel. So we've already taken up 10 minutes of Lordship's valuable time.
Reinventing the wheel means putting an alloy in it. So what?
And there will be no air there, Lordship. The Lordship, sometimes, just off the record, sometimes an issue of law can come out. As a submitted Lordship, I'm not saying I'm correct.
I agree to it.
Why should Delhi High Court be the leading light in interpretation of criminal law? Why can't Meghalaya High Court do it? And court can take either way. Not that it should favor you can overrule my argument and say this is not the correct law. But we can venture out in interpreting the word comma and any. And Lordship, it's not about English and school days grammar. Lordship will correct. Those were the foundation days of how to understand or and. And we thought it so lightly in our school days, maybe, what is the meaning of or and we never realized 40 or 5 years down the line, someday we'll have to justify by our simple English. Obliged for hearing us.
Mr. Khan, it's okay. If you want the tag of a great jurist, we'll give it to you.
No, not in due course. Not at all. We would love the court to lay on some...
In due course.
We happily and give it to him. Not that. We happly and give it to him. Without...
I'm not interested.
But he has posed interesting, questions.
Lordship, for the moment, the majesty of the court will be flowering.
Exactly.
Ultimately, the final seal will be given to the court. I can argue anything, Lordship. Any interpretation of law, anything. The only thing that would require for the court would be Mr. Khan was wrong.
That is
and
a-
overruled.
That is a,
And I'll be the most humble person if I'm proved wrong, because then I'll realize that this was a wrong line of action.
like they say, see, the court can be equally wrong.
Absolutely.
We are not sitting here to be,
I am submitting
as
my
a
humble
no-
submission, Your Lordship. Your Lordship has seen me in most of my cases always to bring more light to the majesty of the court.
But what is this? What is desired is for the parties to project the factual picture
Absolutely.
and to assist the court as to how the law is to be implemented and interpreted.
Absolutely correct. As I said, Lordship, my interpretation can be wrong. If the court interprets after revo or would include that, then my argument is overruled.
If it fits the context of the
Absolutely,
issue.
it's overruled.
Honored Mr. General and Counsel for the Petitioner, who has submitted that the notice upon the Respondent 5 has been affected, for which an affidavit of service has been filed before this court. However, the Respondent 5 has not entered appearance even today. Be that as it may, one more opportunity will be accorded to the Respondent 5 to appear before this court, failing which necessary orders shall be passed. As prayed for by the parties, this is matter of the 1 week.
Obliged. Highly pleased.
Obliged, Your Lordship.
Thank you.
Please, Lordship. This matter is pending for filing of written submission, Lordship. I have not yet filed written submission, Lordship.
What about the petitioner? You are for the petitioner. Have you filed your written argument?
2 weeks' time, Lordship.
Then a counsel for the parties have submitted that the written argument supposed to be filed by the parties could not be filed today and has sought for some time for the same to be filed. As prayed for, this is matter after
2 weeks, Lordship.
2 weeks.
Obliged.
Item number 11.
Yes.
Excuse me.
Please. Against the Lordship, this is an appeal against the conviction order passed by the learned FOXO judge, my Lord, at Tura, whereby, my Lord, the appellant was convicted under Section 8, read with 18, for a period of, my Lord, 1.5 years
My lord, this is an application under 482. I am for the respondent, my lord.
Respondent?
Yeah, my lord.
Where's the petitioner?
I don't know, my lord. Nobody is appearing.
What is the case about, Mr.?
My lord, this is actually 482 filed by the petitioners, my lord. Petitioner and respondent number 3, my lord. They are blood brothers. Now, my lord, these people, this petitioner number 1, my lord,
Yes.
and respondent number 3, they are brothers by blood. Petitioner number 2, my lord, is the wife of petitioner number 1, and respondent number 4 is the wife of respondent number 4, my lord. Now, what has happened, my lord? There are two FIRs filed in this case. The incident is, my lord, pertaining to a property. Now, this, if your lordship will recall, this opposite to Biju Cinema Hall, there is a Didar market, my lord.
Okay.
Now, this whole building belongs to the fathers of this respondent and petitioner, my lord. Now, he is still alive. He stays in Calcutta. In his lifetime, my lord, by virtue of a settlement deed, he has given this property amongst the 4 sons. There are 4 sons, my lord. These are 2. Another 2 is there, my lord. So all this property has been settled. Now, on the second floor of this market, my lord, there is 2 flats. Now, one flat has been given to petitioner, my lord, and other flat has been given to respondent. Now, both are residing in their respective part. Now, on the date of incident, my lord, the respondent has called some workers for making some renovation in his portion of the property, my lord, which was vehemently objected by the petitioner. And in that, my lord, the petitioner, he threatened the workers to leave the premises and also assaulted the respondent number 3. First assault has come from the side of the petitioner. Now, this assault was committed in presence of these workers, my lord. Thereafter, my lord, subsequently, after that, the respondent and his wife went to the portion of the flat of the petitioner as to inquire as to what is his problem, what is his business in interfering with the renovation work. There it was again, an altercation took place, my lord, and there was actually they have alleged that my wife, who's respondent number 4, has actually physically assaulted the wife of petitioner number 1, which was not true, my lord. Actually, if your lordship will come across the record. So there was a fight. Now, what has happened, my lord? On the same date, FIR was lodged. But the FIR lodged by the petitioner was first in time, the matter of only 2-3 hours. I did not know that they are going to file an FIR before me. I had filed on the same day. Now, according to the petitioners, my lord, my FIR is a counterblast, which from no stretch of imagination can be said so, because I filed it on the same date. And in my case, my lord, for which they have come for quashing the FIR, 2 independent witnesses, their statement has been recorded by the concerned IO. Apart from that, my lord, there is a CCTV footage which was also seized by the police. So question of 482 does not arise, my lord. As your lordship is well aware about that case of Bhajan Lal, where it has been clearly stated that 482 can be exercised only in the rarest of the rare case. Now, in my case, there is a witness is there, eyewitness is there, CCTV footage is also there.
But anyway, Mr. Mansoori,
my lord,
you are appearing for all the private respondents?
No, my lord. Government side, my learned friend is appearing. There are
but 3 and 4.
4 respondents are there, my lord.
No, you are
for 3 and 4, my lord.
Exactly. Petitioner is found absent. Respondents are, however, present. Accordingly, this matter is now posted to the next date. List listening after 3 weeks.
My lord. Obliged.